President Biden had told unvaccinated Americans that getting the COVID vaccine is your patriotic duty and an obligation to your country. But one simple inquiry became world famous, asking, what did the president know and when did he know it? The inquiry ends there. Nonetheless, in the courts, we review evidence, both direct and circumstantial, together with reasonable inferences to be drawn therefrom, in the light most favorable to the government, in what is called deference doctrine. However, if the management knows that certain facts will necessarily prevent the regulatory approval, and then goes on to conceal those facts from the investigating public, then there is actionable scienter, knowledge of wrongdoing. That thing we talked about on a hot date. What happens in Vegas stays in Vegas. What happens on the Green Mile stays on the Green Mile, they say. And if you're not inside, buddy, you're outside. I'm one of those guys who tends to float around the periphery. Undisclosed sources. And most recently, even a confidential government informant in a now unsealed matter in the District of Columbia. But who do men say that I am? Well, I had matters before the Supreme Court that have risen to the shadow docket. And according to at least two courts in the Fifth Circuit, I am at least euphemistically described as a litigation hobbyist. According to the federal district court in D.C., I am a federal whistleblower, most infamous for a case with a court-acknowledged protracted history, which has produced a sworn declaration from the Deputy General Counsel for the White House, prompted a 2-year search after 9 months of planning and coordination with the National Security Council, at least suggesting an unprecedented scandal at the highest levels of government, because most of the defendants had held major positions in the administration. With waivers from the U.S. Solicitor General to respond to matters at the U.S. Supreme Court, unless ordered to do so, and prompting claims of presumptive executive privilege, a legal term of art that dates back to the Watergate scandal, and that only appears in a baker's dozen of cases in the entire history of the federal courts. And what has that got to do with me? Well, courts have said that any innocent individual who is harmed by an abuse of governmental authority is assured that he will be compensated for his injury. But Uncle Sam must have some place where he keeps that money, like Fort Knox. The courts have long afforded zealous protection against unjustifiable government interference with the individual's rights to speak and even to vote. And that these may be desirable goals of a system of freedom of expression, a representative form of government, is not to be doubted, according to the courts. These are indeed goals to be pursued by a people whose thoughts and beliefs are freed from governmental interference, mindful that they are not values to be pursued by an implemented order of judicial intrusion into otherwise legitimate state activities. And so, the Supreme Court has said, at least in the past, that where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. And as most people know, in a criminal matter, not a civil matter, prior to any questioning, the person who has been arrested must be warned that he has a right to remain silent as a criminal defendant, that any statement he does make may be used against him as evidence, and as a criminal defendant, that he has a right to the presence of an attorney, either retained or appointed by the court. This is a constitutional right afforded under the Fifth Amendment to protect persons from self-incrimination who have been identified as criminal defendants. And because the privilege against self-incrimination reflects many of our fundamental values and most noble aspirations, often deemed as the essential mainstay of our adversary system, even the Constitution requires that government seeking to punish an individual produce the evidence against him by its own independent labors rather than by the cruel, simple expedient of compelling it from the person's own mouth. This is to protect the defendant in a criminal matter who, during a criminal trial, still maintains his rights, a substantive right assured in procedural due process. 3 Supreme Court justices, Justice Brennan, Stewart, and Marshall, had in the past taken the position that a gag order would never be justified, even to protect a defendant's right to a fair trial. And a 4th, Justice White, had in the past expressed grave doubt that such a prior restraint ever would be justified. However, effectively, in a suspiciously quiet, high-profile defendant litigation dismissed in the federal court, Alexandria, on April 28, 2026, in a civil matter, brought in part under the Freedom of Information Act, or FOIA, which is generally granted a priority in civil actions, such an extreme measure had been taken in a matter that, like many of the plaintiffs' recently filed cases, recycles arguments and allegations related to the COVID-19 pandemic, according to the courts. Clearly, the situation had changed. Why? Court does not say. Procedural due process extends potentially to any statutorily conferred benefit, whether or not it can be properly construed as a liberty or property interest. And this also applies to those rights conferred to persons through laws enacted by Congress, such as under the FOIA. And on complaint, the district court unquestionably has jurisdiction to enjoin the agency from withholding agency records and to order the production of any agency records improperly withheld from the complainant. Since upon receipt of a request for documents under the FOIA, a reasonable trier of fact would be compelled to the conclusion that the agency knew or should have known that the action would have been brought against it. When you don't receive something in the mail that you had ordered, you're probably going to complain about it and not just forget about it. However, on April 28th, the situation had changed. And that was just before David Morans, a former advisor to Anthony Fauci, had been indicted for his alleged role in the scheme to evade the FOIA. In operation, the FOIA is only a right to injunctive relief. A little bit mandamus, but mostly injunctive relief. When a federal agency not already exempted from disclosure unlawfully and without justification withholds requested documents. There are only 9 reasons why the government can withhold information. One of them because it's classified. And normally it goes without saying that an injunction is an equitable remedy, a legal term that you learn in law school. Going back to courts of equity, in which you have to come to court with clean hands. And it is not a remedy which issues as a course, or to restrain an act, the injurious consequences of which are merely trifling. However, with respect to substantive rights like life, liberty, pursuit of happiness, those are deemed to be irreparable harms according to the courts. The historic injunctive process, however, was designed to deter the government not to punish anyone. However, on April 28th, in the federal district court in Alexandria, the situation had somewhat changed. Why? The court does not say. Clearly, the First Amendment provides that Congress shall make no law abridging the right of the people to petition the government, something that not many people even think about in terms of the First Amendment, but you do have a right to petition the government for redress of grievances. And that right is cut from this very same cloth as other guarantees in the First Amendment. And it is an assurance of a particular freedom of expression. This is one of your rights in terms of just being able to go to court. A lot of people think about free speech. A lot of people think about due process. But this also comes out of that right to petition the government. Courts have said, at least, under this provision, where a plaintiff properly asserts federal subject matter jurisdiction, such jurisdiction exists because the plaintiff has alleged what? Violation of his constitutional rights to petition the government for redress of grievances. And the purpose of the right to petition is to guarantee that people may communicate their will through direct petitions to government officials. This is your letter to your congressman. This is your contact with a federal agency. And furthermore, as applicable here, the government may not infringe upon this right either by a general prohibition against certain forms of advocacy or by imposing sanctions for the expression of particular views that it happens to oppose. Still, in the absence of the FOIA, the petition clause guarantees only that an individual may speak freely and petition openly, and that he will be free from retaliation by the government for doing so. No guarantee to respond, but they do give you a right to be heard. But somehow on the 28th, the situation had changed. Why? The court does not say. Normally, a preliminary injunction is an extraordinary remedy, never awarded as of right. However, while it may be true that although the First Amendment does protect a petitioner's right to freedom of expression and to petition the government for redress of grievances, it does not guarantee that there will be any government response at all to such a petition, or that the government or federal courts will take any action regarding the relief demanded by the petitioner. And that's where the FOIA is different, because the Freedom of Information Act contains an express private right of action, even granted priority in civil actions. Indisputably, the loss of First Amendment freedoms, even minimal periods of time, unquestionably constitutes irreparable injury, warranting injunctive relief. However, on April 28th, in the federal district court, with respect to 3 executive agencies, the situation had changed. Why? The court does not exactly say. Although the plaintiff had filed the instant litigation on February 26th, on March 10th, the plaintiff had filed an amended complaint against defendants, according to the gag order imposed against him in a civil matter brought under the FOIA. However, the Supreme Court has articulated that the fundamental requisite of due process of law is the opportunity to be heard, which should occur at a meaningful time and in a meaningful manner. Under the Fairness Doctrine, it's not important that everyone should have a right to get in front of a microphone and speak on television, but that the important things are heard. The Supreme Court has outlined a three-pronged test for evaluating gag orders, that is, injunctions to prevent the press or anyone else from publishing information relating to an ongoing or forthcoming criminal trial. A gag order may only be entered for the benefit of a criminal defendant, not the prosecution. And the criminal defendant must show that without a prior restraint, publicity would impair the defendant's right to a fair trial by irrevocably tainting the jury pool. That any measures short of an order restraining all publication will not ensure the defendant a fair trial, and that it is likely that an injunction will actually effectively secure a fair trial for the defendant. However, on April 28th, in the Federal District Court in Alexandria, the situation had changed. Why? The court does not exactly say. So what happened? What's the big secret? That's why I call it a gag order. Not because of what the 4-page order says, which isn't much, but what is left out. And the court order is kind of like a summary to let all others know what had happened in a court of record. So what did they say had happened? The court never even mentions that this case had involved a FOIA claim. Nobody will know, reading that order, that 3 government agencies decided not to respond to a FOIA request, or that the court decided not to tell the government to produce those documents. What documents? The court doesn't say. In fact, a request for documents from 3 executive agencies. The order does, however, let the reader know that the agencies that were in this case were the State Department, the Department of Health and Human Services, although it calls it the Department of Health and Human Resources, and the Office of Management and Budget, which is the office of the executive of the president. The order also lets all persons interested know that a high-profile defendant, in fact 2, were named in the case, including Mark Zuckerberg and Meta Platforms. But for some reason, the case was handled so quietly that not a word was ever mentioned in the press, not even a morning note. Even though Zuckerberg and Meta had doled out top dollar to retain the best international law firm in the Bay Area. How did that not make it into headline news? Probably because they didn't wear sunglasses to any court hearings, because there were no court hearings that all happened behind closed doors. Well, maybe there were bigger stories, more newsworthy. And at least according to the court, the amended complaint consists of numerous vague and mostly unintelligible discussions regarding a range of unrelated topics. Vague and mostly unintelligible discussions. Just some reports from the World Health Organization and UNICEF, state and federal court cases, and even news articles from the Washington Post, the New York Times, USA Today, the Washington Examiner, and the New York Post, and even the Wall Street Journal. But it is replete with wide-ranging allegations that are repeated countless times throughout, yet lack any comprehensible factual basis. Nothing to watch here, folks. Keep it moving. However, in courts, to adequately plead scienter, knowing culpability, plaintiffs must plead facts to create a strong inference that someone whose intent could be imputed to a corporation had acted with the requisite scienter. Knowledge of While the most straightforward way to establish scienter for a corporate defendant is to impute it from an individual defendant who made the challenged misstatement, that is not even required. The scienter of other officers or directors who were involved in the dissemination of the fraud may also be imputed to the corporation, even if they themselves were not the actual speaker. Alternatively, even a shareholder need not identify the individuals responsible for the fraudulent statement where the statement is so dramatic that collective corporate scienter may be inferred. All allegations going to scienter must show that the individual defendants actually possessed the knowledge, highlighting the falsity of the public statements. Conclusory statements that defendants were aware of certain information, mere allegations that the defendants would have or should have sufficient knowledge is insufficient. However, under the traditional rule, ignorance of the law is no excuse. Catch-22. And the mere promulgation of the ordinance is notice to all. So what do I know that you should already know under the law? On a hot date. Did you know that on November 17, 2021, on my request, the CDC, which is responsible for regulating particularly dangerous toxins and agents, had initiated a regulatory burst after 60 days of public comment very quietly, naming 2 chimeric viruses to add to the select list of agents and toxins, the dirty buck list. And by definition, a chimeric virus can only be the product of a lab. Would you believe that without any press attention at all, while the Delta variant was dominating headlines, the COVID-19 had managed to gain FDA approval before the originally projected date in mid-January 2022. This novel virus was one of those viruses added to that dirty bug list, along with SARS, which had emerged back in November 2002. How did that not make any news at all? Did you know that on February 4th, another hot date, 2020, and again on March 27th, 2020, hindsight is 2020, the HHS secretary had determined that there was no highly contagious disease involved in what had become the COVID-19 pandemic. No highly contagious disease. Well, according to the former HHS secretary, as published in the federal regulations, a capability for a biological weapon described as a CBRN agent or agents. They even have an Army school on CBRN agent or agents at Fort Leonard Wood, Missouri, had managed undeterred to conduct a force projection movement in just 2 months to establish beachheads in 23 nations outside China, resulting in 20,630 confirmed cases globally, 20,471 confirmed cases in China alone, and 425 deaths in that nation, with 159 confirmed cases outside China in 23 countries and 1 death. Thailand. How did that not even spark a manhunt? Bioterrorists running around the world and infecting people. But here's the kicker. According to the Federal District Court on January 23rd, 2025, now long past the normal tolling of statutes of limitations, without the benefit of equitable tolling, which you can only get through Congress or by making a really, really good case in court. Courts have now acknowledged that even military service members had retained their rights to refuse the EUA vaccine and challenge the administration of the product in the absence of a presidential waiver under Section 1107A, 10 U.S.C., and the implementing military regulations. However, like an unwitting motorist encountering a speed trap, according to the state's premier education institution, University of Virginia down in Charlottesville, 80.3% of Virginia residents had received at least one vaccine, not, as is described in the regulations, a countermeasure. President Biden had told unvaccinated Americans that getting the COVID-19 vaccine is your patriotic duty and obligation to your country. And by July 2021, a month before the FDA approval, 73% of uniformed military service members responding to peer pressure had already been vaccinated. But on November 12, 2021, in a very small case not making headlines, DOD had acknowledged that the president had not ever executed a waiver under Section 1107A. And although DOD would not terminate the mandates until December 2023, according to the courts in November 2021, very, very quietly, the DOD could not mandate vaccines that only had the EUA. By that time, vaccines had been approved. So now, it's kind of after the fact. You can't undo being vaccinated. And under 50 U.S.C. Section 1520 AB1, that exception requiring a presidential waiver can only be made for purposes directly related to protection against toxic chemicals or biological weapons and agents, confirming that this novel virus was never a highly contagious disease which had spilled over or even escaped, but a biological weapon that had been used to attack. According to statistics that are quietly reported, only 4.4% of Americans were involved in those attacks. And ignorance of the law is no excuse, but that somehow didn't make news. Why?
I could have had a vaccine.
This message was approved by Major Mike Webb. Honest.
We did all we could do. He just didn't make it.